So I've been arguing with a Canadian sovereign citizen for a while now, who I can't mention, about his case, and mostly he's complaining about the loss of his children. And I thought it would be good to discuss the case without mentioning any names, uh, because as compared to losing, say, your car, or getting your car towed, or losing your house in a foreclosure due to free man beliefs, sovereign citizen beliefs, losing your kids is a different situation. You can buy a new car, you can buy a new house, but you can't buy new kids. You can't buy, a time you lost with your kids. So I thought this is a very instructive case because it shows just how damaging sovereign citizen beliefs can be. And also to sort of defend the judges and government workers involved in this case, because they're being falsely maligned. These are difficult situations, and there's a lot of crying wolf. Oh, the government is doing a bad thing. When if you read the case, it's not that bad. All right, so just to get an idea of what's going on, all the names are going to be blacked out. In February 2010, a temporary guardianship order was made in respect to four children. Quote, the court finds that the children need intervention services and that to protect children's survival, security, or development, the children cannot remain with a guardian. However, it can be anticipated that within a reasonable time, the children can be returned to the guardian. So let's keep in mind, the 2010 order specifically states that eventually the children can go back to the guardians, aka the parents. Now, the order is illuminating because it describes why the children were taken, or it implies why the children were taken. Quote, the order required the parents inter alia to do the following: A, not use drugs or alcohol that are not prescribed for them. B, take alcohol and drug tests as directed by the director. And C, attend and provide proof of attending at parenting, family violence, and anger management courses. So all they had to do was obey those three orders and they could get the kids back. Of course, they chose not to do that. Further on, they described the mother. From the evidence at the PGO, I understand she had a grade 12 education and limited life skills. She was described as homeless with a history of drug and alcohol abuse, having lived in abusive relationships with the two fathers of the children. And I also want to read the next paragraph because, the sovereign citizen angle is ironic here. As you'll see, quote, the second aspect was that the mother said she was on assistance with two children. She would receive $900 per month and would qualify for subsidized housing. With four children, she would qualify for $1,200 per month. She felt confident that she could obtain housing within 2 weeks if the children were returned to her. Council should have realized that corroboration of the availability of subsidized housing would have an impact. So we have a difficult situation here because this is a homeless mother with four children. But the ironic thing here is that they're engaging in all this, the government is bad, anti-government rhetoric, when at the same time they are asking for government assistance, $1,200 per month, and subsidized housing, just to raise the kids. Let's keep, if without the government, these children would starve to death. They require the government to eat food and to have a roof over their head. Reading on. Finally, the judge was concerned about domestic violence in relation to the mother. The mother said that she was not living with the dad and had no intention of living with him. Counsel may have decided to call the father, who was at the hearing, and supported the mother's position to confirm their relationship was over. So, unfortunately, to further complicate things, we have a separation between the mother and the father due to domestic violence. Very common situation. In a subsequent case, we get an update on what happened. Later in 2010, the mother agreed to a concurrent plan to return the children to her, which stipulated, among other things, that she would abstain from alcohol and drug consumption and submit to scheduled drug screening, maintain regular contact with the children by attending scheduled visits, and 3, maintain a safe and secure residence, and 4, provide her family support worker with all necessary information for case planning. Unfortunately, it did not go well. Quote, this was reinforced by the mother's failure to obtain counsel during the adjournment, and by the record showing that she met with her family support worker only irregularly and not as required under the concurrent plan. The mother's lack of diligence was also borne out by the overwhelming evidence put before the court in the course of the trial, demonstrating that the mother was unsuccessful in meeting her responsibilities under the concurrent plan. Her substance abuse escalated. She attended none of her scheduled drug tests. Indeed, she failed to report for a 42-day residential treatment program in May 2011 and for a day program with Alberta Health Services in late June 2011. Having then re-registered in the residential treatment program, she abandoned it prior to completion while absent on a day pass. Her pattern of visits with the children was sporadic. Her domestic circumstances remain unsettled. As of May 2012, she remained homeless, declining her family support workers' assistance in finding housing. Her domestic circumstances continued to pose a risk of violence to her and the children, and as noted, she made very little face-to-face contact with her family support worker. Finally, we come to the father. I note in passing that the father argued at the conclusion of the trial judge that he had assaulted, overly zealously spanked his older child was not only supported by the director's workers, whom the incident had been reported to, but was attested to by their mother, and admitted somewhat begrudgingly by the father himself on occasions where direct evidence under oath was given. It is apparent to me, and I'm sure it was a trial judge as well, that notes made by the director's worker require some care. That being said, evidence of the father's violent character was the subject of hard evidence, including his criminal convictions, and we're going to talk about those. This is the father here. In summary, the father faces charges of intimidating two justice system participants, both lawyers, and breach of probation in relation to earlier guilty pleas for, among other things, intimidating a justice system participant. The father was arrested on these charges on June 18th, 2012. In the course of his arrest, it is alleged that he assaulted 3 police officers, leading to further charges against him for assaulting police officers. On July 4th, 2012, he was denied bail in the first instance. The father presently faces criminal charges. On September 13th, 2011, he pled guilty to 3 charges, 2 counts of intimidating justice system participants, and 1 count of criminal harassment that related to illegal activities directed at employees of Alberta Children and Youth Services. The court accepted a joint submission that the father be sentenced to time served, 4 months, and 1 year probation. The father's misconduct allegedly continued after that guilty plea, and he now faces a further set of criminal charges. Crown has proceed by indictment. Moving on. Here we come to the free man, sovereign citizen nonsense. The father, on April 19th, 2012, filed a lawsuit against an assortment of government actors and employees, peace officers, lawyers, judges, and his former partner and the mother of his children. He claims a range of illegal misconduct and demands $20 million in gold and silver bullion and the return of his 2 children. Now I'm going to mention this because he keeps arguing that he wasn't allowed to defend himself. That's false. Quote, in any case, the father was not denied the opportunity to call witnesses. He testified himself. He called his mother and a friend, I should have blocked that out, to speak his good character. The evidence of 2 additional character witnesses called by the father at the hearing was also before the court at the hearing. I think the fair conclusion on the evidence is that the father understood he could call witnesses with respect to his ability to parent. He would not be permitted to call witnesses about his commercial security agreement. Nowhere have I been referred to a passage in the transcript before the hearing judge where the father requested a witness or requested a subpoena for a witness and had that request denied. Now, further sovereign citizen stuff. Eucadia material. Lastly, the father has attached a one heaven rate register, live born record, and deed of trust. It is not clear what relevance the father purports to put on these materials, as I do not believe they directly relate to his argument that he has not consented to state and court authority. They do, however, disclose an unusual litigation strategy. He also filed a notice of claim of rights. Quote, subsequent to the 20-day rebuttal period in the Notice of Understanding, Intent and Denial of Government, the parent apparently mailed 3 government officials, blah, blah, blah. The remainder of the document, he also filed a fee schedule and a list of rights claim. The fee schedule is a list of fines payable in gold and silver, which the father claimed he is entitled to under certain circumstances, such as if he is detained, $5,000 per hour, shackled or handcuffed, $100 per minute, and for receipt of fraudulent correspondence. An attempt to assert a fee schedule can, however, have serious consequences. And finally, we get to a discussion of stuff that he has been arguing on the comment section. The father says he believes that the government actors have no authority over himself and his children unless he consents to that authority. He says he has not consented and has opted out of Canadian society and its legal restrictions, rules, and principles. That, however, is not how things work. All persons who are present in Canada are subject to its laws. The Canadian Constitution, including the Charter of Rights and Freedoms, legislation passed by the 3 levels of government, as supplemented by the common law created by the courts. Those laws collectively both restrict conduct, structure our interactions, and protect our rights and persons. I will now review the mechanism by which the father says he has obtained his special status. This is hilarious here. As a preliminary observation, the father does not explain why he, as a biological father, has the sole authority and custody of his children, other than what appears to be a quoted Latin phrase in his statement of claim. Partus sequitur ventrum. The offspring follow the condition of the mother. This is the case of slaves and animals, but with regard to free men, children follow the condition of the father. You got that from Bouviers. As I am unfamiliar with this principle, I investigated and learned that this is a concept of Roman civil law that related to the definition of slavery and was applied in the United States as a basis for slave owners to impregnate their female slaves and then sell their own children as property. Thomas D. Morris, Southern Slavery and the Law, at page 43 to 52. Needless to say, this is not the law in Canada. Here, male and female parents have equal rights and obligations in relation to their children. So you heard that right. This guy actually used slave laws from the slave era in the United States to argue that he had sole custody. So he was as a father, he's the only one that has any rights to his children. Now, the icing on the cake is that not only did he lose his children, but he also had to pay $10,000 to the people he sued, $7,500 to the RCMP, and $2,500 to a Miss Quinn, who I don't know who that is. So he had to pay $20,000 for filing this Freeman lawsuit. And he still hasn't gotten his kids back. Now, let's keep in mind, as at the beginning of the video, we established all he had to do to get his kids back was A, not use drugs, B, take alcohol and drug tests, and C, take classes. That's all he had to do. And that was back in 2010. It's 2017 right now. This has been going on for 7 years. This guy has been avoiding taking these drug tests and taking these courses, and has instead been listening to Eucadia, which is Franco Collin, what's it called, Robert Menard, all these idiots. He keeps signing Mark Stevens. He's been listening to that crap for 7 years, and as a result has not gotten his kids back, when all he had to do was take these courses, prove that he can be a good parent, and that's it. This is a real irony of the situation. He could have gotten his kids back if he hadn't gone down this sovereign citizen freeman route.